Welcome students to third lecture in the series of Indian Contract Act which we have started on our channel Learn Law with Professor Rashmi. Those who have not watched the earlier first and second video, please go and watch those videos on Indian Contract Act. Also on the channel you will find other videos which talk about how are you going to attempt your law exams, how are you going to solve the situation based problems in exam, how to manage time wisely, how to prepare for exam well, and all these things you will find on the channel. I am also going to give the link in the description box. Do check those videos. And for all those who are just getting benefited by the channel but not subscribing, I will please remind you and request you to do subscribe to the channel, because subscription is totally free for you and I'm taking lots of efforts to make these videos. So moving ahead without wasting much of our time, let's start with the third lecture in the series. In earlier lecture, we have already devised or deciphered the formula for contract, which talks about how we have deciphered. You can go back and watch that video. But as of now, a formula for contract would be proposal, acceptance plus consideration and legal enforceability. So we are going to discuss it one by one. We'll start with proposal. So what is a proposal? Proposal is defined in section 2A of Indian Contract Act, which talks about the definition of the proposal, like when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. In Indian law, we call it as a proposal, and in English law, we call it as an offer. So these terms are always used synonymously and they mean one and the same thing. Always remember that. After seeing the definition of proposal, we can divide this definition in these 5 parts. What you can do is you can just underline or make brackets and divide the definition in such a way so you are reading the definition. After seeing the proper division of the section, we have now come to the essentials of valid proposal. From the definition, we see that there are 3 essentials of valid proposal. First is communication of offer, second is intention to create a legal relationship, and third is it should be an offer and not invitation to treat or invitation to offer. Let us start discussing each essential one by one. First, offer must be communicated. So when I say there is a proposal and it was accepted, you know that it becomes an agreement. But for offer to be accepted, isn't it necessary that you should know the offer? Unless and until you know the offer or the person knows the offer to whom which offer is made, how can he accept it? So suppose I am having in my mind that I will offer you to sell my laptop to you, second-hand laptop to you, but it is in my mind and I have not communicated it to you. How are you going to know the offer? And if you are not knowing the offer, how are you going to accept it? So basically, communication from the offerer to the offeree is important. Section 4 talks about when such communication can be complete. Section 4 says that the communication of proposal is complete when it comes to the knowledge of person to whom it is made. So if I am making a proposal to another person, when the person is coming to know about this proposal, that communication is said to be complete. So illustration to section 4 reads like A proposes by letter to sell a house to B at certain price. The communication of proposal is complete when B receives the letter. So it can be any mode of communication, but as soon as it comes to the knowledge to whom the proposal is made, that is offeree, the communication of proposal would be said to be complete. Now let us discuss a scenario where a person is acting in an ignorance of offer. So basically offer was the person is not knowing the offer, but still he is acting on the terms of that offer. Would it amount to acceptance of an offer? So try to understand a situation that there is some offer which has been made, but the person is not knowing that such offer was made. Still he is acting according to the terms of that offer. Then in such case, would his action amount to acceptance of an offer? This was discussed in landmark judgment, an interesting case. Let us see. So this landmark judgment is Lalman Shukla versus Gauri Dutt, 1913. So here Lalman Shukla is plaintiff and Gauri Dutt is defendant. So Gauri Dutt's nephew had absconded from house and plaintiff, that is Lalman Shukla, was that Gauri Dutt's servant and he was sent to search for a missing boy. After plaintiff had left in the search of the boy, defendant also issued handbills announcing reward of 501 rupees 500. See, in 1913 they were very important, or they had much high value. So plaintiff issued handbills, that is this Gauri Dutt issued handbills saying that anyone who searches the boy will get rupees 501. Now since plaintiff, that is Lalman Shukla, had already been out for searching the boy, he was not knowing about such distribution of the handbills and such offer which was raised by Gauri Dutt. Now, when he came to know about the reward, and he was successful in searching the boy, this Lalman Shukla was successful in searching that nephew, and when he came to know about the reward, which was announced in his absence, he brought an action against defendant, that is Gauri Dutt, that I want rupees 501. Court said that since plaintiff was ignorant of the offer of reward, his act of bringing the lost boy did not amount to acceptance of offer. Therefore, he is not entitled to claim the reward, because he was not knowing the offer, though he has acted on the terms of offer. Since there was no offer which he was knowing, it cannot be accepted, and therefore there is no contract that has come into existence, and therefore he is not entitled to claim the reward. Court also commented that since he was serving his duty as a servant, this also counts that he won't be eligible for the award. Next, second essential, intention to create a legal relationship. So unless and until there is no intention to create legal relationship, contract cannot come into existence. So offer should be made with an intention. So I should make an offer to you so that I wish to enter into a contract with you. Like agreement to go for walk or go for movie, play some game with your friends cannot be enforced in court of law. Why? Because there is no intention to create legal relationship. It comes only under a type of social relationship. There is a interesting and landmark case, Balfour versus Balfour, where husband and wife who used to stay in Ceylon went to England for a vacation, and there that wife started suffering from some type of ailment where doctor advised her that she shouldn't go back to Ceylon because going back to Ceylon may aggravate her condition. So therefore she was advised to stay back in England, while husband had to go because he had his business in Ceylon. So what was decided between these husband and wife, that she would stay in England until her health is coming back to normal. Till that time, this Mr. Balfour will send her certain sum of money every month so as she can use it for maintenance of her expenses. Now after a few months, this Mr. Balfour stops sending the amount, and Mrs. Balfour goes in the court of law saying that there was a contract between husband and wife that he is to send me such and such sum of amount. Now court held that there is no intention to create a legal relationship, and that is the reason this is no contract and cannot, such condition of payment cannot be enforced against Mr. Balfour. So here court held that the intention of the parties should be objective, it should not be subjective. Because only promisor is saying that there is intention to create legal relationship, that doesn't mean there was. So the circumstances of the case would be essential to know whether there was intention to create legal relationship or not. Generally, you will see that in case of close relationship like mother-daughter, child and mother, or husband-wife, or brother-sister, and all those things, there are generally, these are close relationship, and in day-to-day life there is only what you can say, a relationship conversation which happens, and there is no intention to create legal relationship. But that doesn't mean that there cannot be a legal relationship or intention to create legal relationship between close relations. Let us see another case law. Merritt versus Merritt, 1970. Now this is also an husband and wife case where husband and wife were joint owners of the building, and such building was subject to mortgage. Such flat which they were having in the building was mortgaged to the society. Now this husband left the matrimonial home to live with another woman. At that time, when the husband was leaving the wife, this Mrs. Merritt insisted that husband should sign a note saying that Mrs. Merritt will pay all the outstanding amount with respect to the loan and get the mortgage removed from the society. In return, husband should give in writing that I will agree to transfer the property into your sole ownership, and this note was signed by Mr. Merritt. Court held that in this case it is clear that parties intended to create legal relationship, and therefore this was a contract and husband was bound by the contract. So though this is this transaction is coming out of close relationship of husband and wife, Nevertheless, there is a clear intention to create a legal relationship. It was held by the court in this case. So most of the times in close relationship, you will see that there is no intention to create legal relationship, but at times, yes, as per the circumstances, it can be derived whether the legal relationship intention existed at that time between the parties or not. Moving forward to the third essential, offer or invitation to offer has to be distinguished. So offer has to be distinguished from invitation to treat or invitation to offer. So if I am going to the if a bookseller is sending me a catalog which indicates the prices of the various books, this catalog is not offer to sell the goods, but it is only an invitation to offer. Inviting the persons to an auction is also an invitation to treat. Advertisement calling for tenders is also an invitation to treat. Also, if you are going to a restaurant, the menu card which is given to you is also an invitation to offer. When you place the order is the offer you make, and when you are provided with the whatever order which you have placed is acceptance. So basically all those things would be an invitation to offer. So the person like the bookseller will have every right to deny that I won't sell this book to you, or a restaurant guy, of course this won't happen, but restaurant guy has every right to say no to serve you, because menu card which is presented to you is only an invitation to offer or invitation to treat. Harvey versus Facey is one of the leading case laws. Bumper Hall Pen case, so it is also known as Bumper Hall Pen case or BHP case, popularly known as. So herein the Facey was owner of plot of land which was known as Bumper Hall Pen. So plot of land name is Bumper Hall Pen, and plaintiff were interested in the plot, so they sent a telegram to defendants, will you send BHP, telegraph the lowest price. Here the Facey telegraph lowest price for BHP is $900. However, they did not respond to the first question, that is will you sell BHP. Plaintiff sent another telegram. So lowest price is $900 which was sent by Harvey, and plaintiff sent another telegram, we agree to. Contentions of the plaintiff were the second telegram from defendants, that was quoting the price, was an offer which has been accepted by the plaintiff, and hence contract was complete. However, defendants contended that quoting price was not an offer and which could not be accepted. Judicial Committee of Privy Council in this particular case held that the exchange of above stated telegrams has not resulted into a contract. First telegram had two questions as to price and willingness. Only the price was quoted and willingness was not expressed, therefore that was not an offer. Third telegram, that is we agree to buy for $900, can be said to be an offer and it won't be an acceptance to offer. So this is one of the important case law where when we talk about offer and invitation to offer. With this, we have completed the essentials of valid proposal. In next lecture, we will see essentials of valid acceptance. Till the time, stay tuned to the channel. Let me know your feedback in the comment section. Bye. Thank you.